Good evening, everyone. Hopefully you could all hear me now. Welcome. My name is Karen DiMiola, and I am a past president of the Connecticut Bar Association and a member of the Connecticut Bar Foundation Board. During the day, I serve as Dean for Diversity, Belonging, and Community Engagement at UConn Law. It is my pleasure to welcome you to this session, which is part of the Constance Baker Motley Speaker Series on Racial Inequality, established by the Connecticut Bar Association and the Connecticut Bar Foundation. We look forward to continuing to explore topics related to racial inequality throughout the remainder of this year. Constance Baker Motley was a trailblazing civil rights attorney who became the nation's first African-American female to serve as a federal judge and later chief judge. Judge Motley was born in New Haven, Connecticut, and maintained strong connections to Connecticut throughout her life. Before we begin, I also ask that you all view the chat function for this session's CLE codes and link to record the codes. We will be sure that the codes are read aloud and posted in the chat during the presentation. Additionally, at the close of the session, we hope that you will provide feedback on today's presentation using the survey link provided in the chat. Today's session is titled "The World According to Dobbs, Racial Inequality and Starry Decisis." We'll have a very informative discussion on the history and background of contraception and abortion rights, the reason behind the expansion of these rights over time, the relationship to other non-abortion rights substantive due process cases, legislative developments, and the specific impact on women of color. Tonight, we are joined by Ken Barchi, an appellate attorney at McElroy and Deutsch, Cynthia Suhu, who is a professor of law and co-director of the Human Rights and Gender Justice Clinic at the City University of New York School of Law, and Dr. Nancy Stanwood, Chief Medical Officer of Planned Parenthood of Southern New England. I want to thank our panelists for joining us tonight. And I want to thank Judge Shaw for joining me in co-hosting this evening's session, along with our amazing committee members, Jenna Cutler, Alex Simonetti, and Michelle Cajero. Thank you all for being here. I appreciate it and look forward to the conversation.
Great. Well, good evening. And I want to thank the Connecticut Bar Foundation for inviting me and for organizing this CLE. I'm going to be discussing constitutional protections for abortion prior to the Supreme Court's decision in Dobbs versus Jackson. And then Ken is going to zoom out to situate the right to abortion within the broader constitutional protections for liberty and privacy. But before we talk about Roe versus Wade and the law before Dobbs versus Jackson and why it's such a critically important case, I think it's also important to recognize what Roe versus Wade did and what it didn't do. Roe and later Planned Parenthood versus Casey recognized a constitutional right to abortion. This created a legal right and a legal floor to protect abortion access, and this prevented the state from banning abortion. But we need to understand that the legal right to abortion was really never enough to ensure that all people could actually access abortion services. And I know that Dr. Stanwood is going to talk about that in greater detail later. Because even under Roe versus Wade and Planned Parenthood versus Casey, Congress and the states were allowed to adopt measures designed to dissuade people from having abortions and to make it difficult or impossible for them to access abortions in reality. And this included passing laws excluding coverage for abortion under Medicaid coverage, imposing waiting periods that impeded people's access to abortion, adopting unnecessary regulations that forced clinics to close, even as abortion remained legal, right? So that's the thing that we need to understand. Planned Parenthood versus Casey and Roe versus Wade created a legal floor, and this prevented states from making abortion illegal, but it did not prevent the state from creating obstacles that prevented people from accessing abortion. And even before Dobbs, prosecutors found ways to prosecute people who self-managed abortions and suffered suspicious pregnancy losses. And these barriers, the ones that the state ignored, exploited, or actually created, disproportionately affected poor people, people living in rural areas, and people of color. And so I just want to emphasize again that though the constitutional right to abortion was never enough to ensure access, it did provide a critical floor. And it was a legal right that blocked the state from making abortion illegal and forcing people to continue a pregnancy and give birth against their will. So what did Roe and Casey actually say or do? I think the top line is really to understand that Roe and later Planned Parenthood versus Casey recognize that while states may have a legitimate interest in protecting prenatal life and regulating the safety of abortion, pregnant people have had a constitutionally protected right to personal liberty that protected them from being forced to bear a child. And specifically, Roe and Casey recognized that liberty protected by the 14th Amendment included the right to decide whether to terminate a pregnancy. And Casey talks about, that there's a long history of women in the United States occupying an inferior position in the US. But Casey found that the development of the constitutional jurisprudence and societal developments required that the Constitution protect all individuals, male or female, from the abuse of governmental power or unjustified state interference. And for a body with a uterus, the court recognized that autonomy over childbearing is a key component of liberty. And on the other side of the equation, the court rejected Texas's claim that unborn persons are legal persons under the Constitution with protected rights. I mention this because I think we're increasingly going to see claims that unborn people are prenatal life are people protected under the Constitution, but this was squarely rejected in Roe versus Wade. The court recognized that while states have a legitimate interest in protecting prenatal life, states can't adopt a theory of life that imposes their moral choice on the bodies of pregnant people and force them to bear a child. This was the careful balance that Roe and Casey struck, recognizing that people have a constitutional right to control their bodies and the course of their lives, and these rights can't be taken away by the state based on its view of the value of prenatal life. This balance was reflected in Roe's trimester framework that I'm not going to go into detail into, but I just want to note that Roe adopted a trimester framework, which was later reformulated in the 1992 case Planned Parenthood versus Casey. So in the 1992 case Planned Parenthood versus Casey, the court reaffirmed Roe's essential holding, and that is that the state can't prohibit a woman from making from making the ultimate decision to terminate a pregnancy before viability. But it changed the standard from Roe versus Wade's trimester standard, and it essentially adopted a two-part standard. It gave states more power to regulate abortion to further the state interest in fetal life and ensure that abortions are safe prior to viability, as long as the regulations didn't impose an undue burden on access to abortion. So Planned Parenthood versus Casey really opened the door for the states to pass greater regulations as long as the regulations didn't impose an undue burden. But Planned Parenthood versus Casey reiterated that states can't ban abortion prior to fetal viability, which is generally understood to be about 24 weeks. And this has never been an issue of dispute, and it was a very easy standard for courts to apply. This idea that the state cannot ban or the state could not make abortion illegal prior to 24 weeks. There was some conflict about how the state applied the other part of the standard, the undue burden part. And states sort of used this ambiguity to pass laws that regulated abortion and really over-regulated abortion, forcing clinics often to close based on things that purported to be health regulations, but really weren't imposed on any other kind of medical procedure, right? And it was really a way to force clinics to close without banning abortion outright. And just 6 years ago in 2016, while Justices Ginsburg and Kennedy were still in the court decided a case called Whole Women's Health versus Hellerstedt, which reaffirmed the Roe and Casey standard, but really put more teeth into the undue burden standard. And really made it more difficult for states to sort of cynically pass laws that said that they were about making abortion safer, but really were about making imposing health requirements and safety requirements that were really impossible for clinics to follow in any way that they could afford, right? So as late as 2016, again, the Supreme Court reaffirmed Roe versus Wade and actually put more teeth into the undue burden standard. But then some changes start to happen at the court. And I'm going to turn it over to Ken, who's going to talk about the broader constitutional protections for liberty and privacy. I'm going to stop.
Thank you. So abortion, of course, the word abortion doesn't appear in the Constitution, but there are a lot of other rights that we regard as fundamental that don't appear in the Constitution either. So how this came about is there's been a long history of the court recognizing certain fundamental rights that have been deeply rooted in our traditions and history. So, for example, the right of parents to send their kids to a sectarian school is a constitutional right. The right of parents to have language instruction, foreign language instruction for their kids is a constitutional right. Those are cases that are quite old. The right to marry is fundamental. In the cases that lead most directly to Roe start with Griswold versus Connecticut, and here's Connecticut's contribution to liberty interests in that Connecticut outlawed the use of contraceptives by anyone, but including married couples. And so the challenge in what the court ultimately held is that there's a right of privacy, that at least a right of marital privacy, that the state cannot interfere with when it comes to choosing whether or not to use birth control. Now, the majority opinion was written by Justice Douglas, and he said, well, there's the First Amendment, the Third Amendment, which has to do with quartering of soldiers, the Fourth Amendment, which is search and seizures, the Fifth Amendment, which is due process, and the Ninth Amendment, which leaves rights to the states. Those form a penumbra in which there's a zone of privacy. Now, that has been analysis has been roundly criticized, but that was the basis for it. One of the justices concurred, but said that really it's a liberty interest under the 14th Amendment due process clause. So that was, but they were also the court was very careful to limit it to marital privacy. 5 years later, in 1972, the court decides Eisenstadt versus Baird, in which it says single people have a right to use contraceptives as well. The right to privacy has to be applied equally. And so sort of unceremoniously through the 14th Amendment expanded Griswold. And one of the things that Eisenstadt said is that privacy means free from government intrusion into fundamental decisions like whether to bear a child or not. And then Roe was the next case, and Roe, at the time, the Roe talks about grounding in the Ninth Amendment and based on Griswold and Eisenstadt. And that was again the sort of the basis. There was a justice again concurring, saying it's the 14th Amendment liberty guarantee, but there started to be a shift from relying on the Ninth Amendment to going to the 14th Amendment, and that starts in Carey versus Population Services, which was another birth control case, and that struck down a prohibition on the sale or distribution of contraceptives to minors, or distribution by anyone other than a pharmacist, and then also to bans on advertising contraceptives. And in that case, it said the right to privacy is rooted in the 14th Amendment guarantee of liberty without no one will be deprived of liberty without due process of law. So the right to privacy, the right to self-determination, the right to family structure says the pendulum swings back and forth. In Bowers versus Hardwick, for instance, in 1986, the Supreme Court held that same-sex couples do not have a right of privacy when it comes to physical intimacy. There were laws since the beginning of time against sodomy. It was not deeply rooted, and then the court defined the right very narrowly in that instance. But then in Casey, again, that was which revisited Roe versus Wade. That was squarely rooted in the right to abortion, squarely rooted in the 14th Amendment. And now remember, by this point, Justice Kennedy is on the court. He starts to talk about personal choice is central to the dignity and autonomy, and that becomes a theme in privacy and liberty cases going forward. After Casey was Washington versus Glucksberg, which has sometimes posed a problem in defining fundamental rights, because that case involved whether there was a constitutional right to physician-assisted suicide. The answer was no, there isn't. But what the court said in its analysis is that the rights have to be deeply rooted in our history, and it's important to precisely define what those rights are. So this whole becomes, whether a new right is going to be recognized or not becomes a question of framing. If it's narrowly framed and there's not a history to support it, it's probably not going to be recognized by the court. So fast forward to 2003 in Lawrence versus Texas. Now, Lawrence versus Texas overruled Bowers versus Hardwick and said that same-sex couples have a liberty interest in a privacy interest in engaging in intimate conduct. Now, what the majority said is that this is not a right to engage in specific conduct; it's a right to form relationships and to be able to express yourself within that relationship. So it's again a strong theme of autonomy, making personal choices, that are very consequential to one's life. And again, there was an emphasis, this was Justice Kennedy, there's an emphasis on dignity, and that Bowers demeaned gay people. And then this led finally to the most recent case is Obergefell versus Hodges, which, unless you've been in a time zone other than this reality for a while, you've probably heard about. There, the court held that the same-sex couples have a fundamental right to marry. And what's interesting about this is it's sort of a combination of both the 14th Amendment due process right, substantive due process, versus and an equal protection component to it. In other words, the right to marry is fundamental. Same-sex couples have the same right to access it. And Lawrence and Obergefell both relied on earlier cases, Griswold, Eisenstadt. Lawrence relied on Roe and Carey and Casey to develop the law to get to the point where to recognize the rights of same-sex couples in relationships. So this is how Roe and Casey are sort of part of that, or at least were part of that web of who making the liberty to make decisions fundamental to who we are as people. And I'm going to toss it over at this point to Dr. Stanwood, who can talk about life before Dobbs and what that actually meant for abortion rights.
Thank you so much. Again, I'm Dr. Nancy Stanwood, she, her pronouns. I'm the Chief Medical Officer of Planned Parenthood of Southern New England. I'm a practicing obstetrician gynecologist and a proud abortion care provider. I'd like to start with just some headlines when I think about this topic, to remind people in the audience, when it's not an audience of medical people, or maybe medical people who aren't in OBGYN, I'd like to let you know that abortion is common, that abortion care is health care, and that access to abortion is really critical for the well-being of people who can get pregnant, because forced birth is a violation of a person's human rights and an assault on their dignity. I'd also like to remind us that not just women need abortion care, that trans people and non-binary people need and have abortion care as well. So you'll hear the language that I use recognizes that important reality. I want to thank you, Cynthia, for the visual of building under construction and reminding us that Roe was only the floor. Roe was actually never enough to ensure that people had access to care, particularly people who come from minoritized and disenfranchised communities, such as people of color, people living in rural states, people from the LGBTQ community, and that those groups are the ones who are harmed most by unnecessary restrictions on access to care. I'd like to give you sort of a quick whirlwind tour of racial disparities in sexual and reproductive health, because healthcare mirrors the broader society. And we know that racism and other oppressive structures not only exist in healthcare, but in many ways are baked into the structure of the system. So it's not surprising to see manifestations of structural racism, and particularly anti-Black racism, in sexual and reproductive health outcomes. So I just want to go over some common measures and compare some statistics for people who identify as white as opposed to people who identify as Black. Starting with contraception. And I'll just do a quick sideline that Estelle Griswold was the president of Planned Parenthood of Connecticut. And she started an abortion, a contraceptive clinic, and told the police to come and arrest her. And they did. So that's how we had that decision. But in access to contraception, when we look at people who are at risk for unintended pregnancy, meaning they're fertile, capable of getting pregnant, and having the kind of sex that could get them pregnant, that 9% of white people are not using contraception in that circumstance, as opposed to 15% of Black people. And that really is about a lack of access to care, as well as historically a well-founded distrust of the medical community when you think about the egregious history of forced sterilizations and what a Mississippi appendectomy was. When it comes to abortion, the need for abortion care is concentrated in communities with limited access to comprehensive reproductive health care, including contraceptive care. So that, well, in our country right now, 13% of the population identifies as Black, 37% of people who have abortion care identify as Black. And Black people are more likely to need abortion care in the second trimester, which is a manifestation of delays in access to care. When we look at birthing people, Black birthing people compared to white birthing people have 2 times greater risk of complications and 3 times greater risk of death related to pregnancy and delivery. When we look at infertility, Black people have twice the rate of infertility and lack of access to in vitro fertilization, largely because of entrenched poverty. And when we look at gynecologic cancers, Black people have lower survival rates for endometrial cancer, cervical cancer, ovarian cancer. So we know that these disparities are a significant part of what Black people experience in our society and in access to care and receiving care in America's healthcare system. I wanted to turn a little bit to a really important study that was conducted out of UCSF from the Answer program there, called the Turnaway Study. It's a seminal work in the field of social science and understanding what does access or lack thereof to abortion care mean for people. Because sometimes in the rhetoric around abortion care, there's this idea of like, well, just have the baby, as if everything is going to be fine. So an amazing group of social scientists recruited people who presented for abortion care, some of whom were just before the gestational limit at the center where they presented, and some were just after and they were turned away, hence the name Turnaway Study. And they followed these people with in-depth interviews every 6 months for 5 years to see what happened. And when you looked at people who were not able to have the abortion that they had decided they wanted and needed, compared to those who were able to have the abortion, those who were not able to have the abortion had higher rates of anxiety and lower rates of self-esteem, lower rates of life satisfaction. They did have similar levels of depression in both groups. From a socioeconomic point of view, when you checked in 1 year later with people, those who had been denied the abortion that they knew that they needed were more likely to be living in poverty, to be raising children alone, and to have stayed with an abusive partner. So while people are resilient, denial of abortion care has significant long-lasting effects on people's physical, social, and financial health. And this has been true before the Dobbs decision, when we look at all of the barriers that were placed in people's way to accessing care, such as 24-hour waiting periods, mandated state counseling that was not medically accurate, and mandatory ultrasounds, in addition to lack of insurance coverage, denying insurance coverage for abortion care. So I'm going to pause there because we're going to wait for the then came Dobbs part of the discussion. But I just want to remind people that while things are quite dire now, it's not as if things were good and hunky-dory when it came to ready access to this time-sensitive care before the Dobbs decision.
So before Dobbs, we Planned Parenthood versus Casey and the undue burden standard was the law of the land. And again, I just want to reiterate the standard held that there could be no bans on abortions prior to viability, which is at 24 weeks, and that regulations couldn't impose an undue burden on a person's ability to access abortion care. And then things started to change. We begin to see that the court's abortion jurisprudence becomes more unsettled as new conservative members joined the court in 2017, 2019, and 2020. And suddenly, once Justice Kavanaugh was appointed to the court, we see states passing laws that were clearly unconstitutional. This includes unconstitutional bans on abortion before viability and even bans at conception. So even though the law was clear, states sort of felt like they saw the writing on the wall and started passing laws that were clearly unconstitutional. And once Justice Barrett joins the court and there's a 6-3 conservative majority, everything changes. And I just have a little post-it from the dissent in the Dobbs decision, and which says the court reverses course today for one reason and one reason only, and that's because the composition of the court has changed. So I just want to put that out there as we're thinking about the legal, what was in the case itself, just thinking about the broader context. So what was the Dobbs case about? The case actually involved a ban on abortion at 15 weeks, which in today's, I think, environment seems mild, but actually a ban on abortion at 15 weeks over the summer or before the Dobbs case was clearly unconstitutional, right? Because viability is at about 24 weeks. And 5 justices signed on to Justice Alito's majority opinion, which completely overturns Roe versus Wade. It's signed by all the conservative members of the court except Justice Roberts, who really is no longer needed for the majority decision. Justices Thomas and Kavanaugh write concurring opinions. Justice Roberts would actually concurs in judgment. So he would have allowed the 15-week ban, but he says that there was actually no reason to completely overturn Roe versus Wade. He would have continued to recognize a constitutional right to abortion, but he would have applied a watered down standard saying that that constitutional right to abortion only required that the state provide a pregnant person a reasonable opportunity to exercise their choice. And he would have said that 15 weeks would have been a reasonable period of time. I disagree with that. And I also think Justice Roberts probably had more of a long-term strategy where he was going to chip away at abortion rights, but technically his decision would have continued to recognize a constitutional right to abortion. And then there was an unusual joint dissent authored by Justices Breyer, Kagan, and Sotomayor. And so what does Justice Alito's majority decision say? He says that basically the court got it wrong for 49 years and that the Constitution actually doesn't protect a right to abortion. And he says that the proper standard for the court to apply when the state regulates abortion is a rational relation test. And he does this through a cramped reading of what liberty is that's protected by the 14th Amendment, saying that we would look to rights that are deeply rooted in this country's history and tradition and implicit in the concept of ordered liberty. In terms of stare decisis, he says it's not an inexorable command. And I know Ken is going to go into these issues in more detail, but he says it's not an inexorable command and the court can overturn cases that are egregiously wrong, which I think really just means the court, if we disagree now, it's egregiously wrong and we can overturn cases. So Dobbs really resets the constitutional balance, and it says that pregnant people don't have a constitutionally protected right to abortion, and the state can impose its belief on their bodies. it does this really by, again, applying a really selective originalist test, which narrowly looks at history and tradition. But I think there are many ways you could look at history and tradition, and the court just chooses to look at state laws making abortion illegal in around 1868 when the 14th Amendment was ratified. And by just focusing on this history, the court doesn't even acknowledge the real invasion on the bodies and lives of people when the state can enforce forced pregnancy, right? They're just looking at this technical question of whether states made abortion illegal in 1868, and the court doesn't even really grapple with the undermining and the state's control over and taking away the autonomy of pregnant people. Alito's careful to say that the decision is not based on any views about when prenatal life is entitled to rights, but I think implicit in his decision are assumptions about the moral status of prenatal life. And the other thing I think is that we need to keep in mind is that by removing constitutional protections, he really opens the door for states to impose their views about when life begins or the value of prenatal life on the bodies of pregnant people. So here are some quick critiques of Alito's test. This sort of backward-looking test, looking at history and tradition, really privileges the rights of white, cisgendered, straight Christian men, right? We're looking at 1868. And this is a time when women couldn't vote and women weren't even conceived as full and equal citizens. And there are other critiques in terms of that his look at the historical record is actually very problematic. He's really cherry picking, looking at 1868 when in fact abortion was legal prior to 1868 and when the country was founded. He also ignores the fact that the Reconstruction Amendments were drafted after the Civil War, and congressional record really indicates that the intent was to address issues like reproductive autonomy and issues like forced pregnancy and childbearing, which were really conditions of slavery. And just this idea that the Reconstruction Amendments were about transforming the country, and this idea that we're going to be tied to what was legal in 1868 doesn't even make sense from sort of thinking about the intent of the drafters of the 14th Amendment. And the other thing just to keep in mind is the test also really threatens other precedent around intimate private decisions that Ken talked about earlier. I'm going to skip this. Right, and so again, the case really endangers the decisions around the intimate decision-making, and it really gives states enormous power to protect and recognize rights for fetal life without any federal constitutional limitation, right? Because what Roe did was really it imposed a national standard and a minimum level of protection. And now it's really up to the states, and whether or not abortion is legal will depend on the state where you live. States can criminalize people who provide and have abortions. States can define protected life to begin at conception and include zygotes, embryos, and fetuses, with implications for contraception and IVF. And the other thing we've seen is that litigation has really moved to state courts. And so this is actually from the New York Times. And right now, I think, sorry, I think it's like 13 states have totally banned abortion. Georgia has banned abortion at 6 weeks. 4 states have banned abortion at 15 or 18 weeks. On the right, you see states where abortion bans have been passed, but they've actually been blocked through litigation. And these are states where abortion remains legal. And it's just interesting to take a look at that map and think about how far people have to travel to actually access services and sort of the crucial need for clinics in states like Illinois and New Mexico. I think I'm gonna turn it, I think I'm turning it over back to Dr. Stanwood. I'm gonna stop my share.
So in thinking about after Dobbs, again, Cynthia, something you said just struck me in the majority opinion that things need to be deeply rooted in this nation's history and traditions to have that implicit concept of ordered liberty. Well, if you think about in 1776, women were considered the property of their fathers, brothers, or husbands under the law, and Black women were property. So I think that the view taken really disregards the expansion of the franchise, expansion of the recognition of the human rights and civil rights of a whole cast of a whole large segment of the US population. I want to think about what does the Dobbs decision mean from the medical point of view, and to frame for you that it's very early days. It's not as if we have, a robust study over the past year under this precedent, because it's only been 6 months almost. But we can have some idea, because we can expect some of the barriers of access to care and health injustices of the pre-Dobbs era to become more manifest, more widespread, and to deepen. But I want you to think about, okay, you're a patient in one of those states that has banned abortion, and you find yourself pregnant, and you don't want to be pregnant. What are your options? Knowing that the Turnaway study tells us that just staying pregnant, usually the reasons that people want to have an abortion are justified, as far as it could be a real struggle or really dangerous or difficult to continue the pregnancy. So one of the first things that people can do now is they can travel. Traveling for abortion care existed before the Dobbs decision, but it has become much more common now. And recognizing that the ability to travel for care is an economic luxury. And part of what is filling the gap there to try and ensure access to care for patients who don't have a credit card with a high balance that they can max out is abortion access funds. And I'll talk about that in a little while. But there is a whole army of volunteers who have been working for decades to try and make access a reality, who now are really going into high gear to provide people with financial and logistical assistance to be able to travel for care. In Planned Parenthood of Southern New England, which is Connecticut and Rhode Island, we have seen an increase in the number of people coming from out of state, particularly when you disregard our closest states and look for farther away, so that actually the average distance traveled for patients coming from other states has tripled since the Dobbs decision. And I'll just share an anecdote that I had one procedural abortion day that I was covering, and it was in the summer. It was still hot. It was a busy day. And in that one day, I took care of 3 people from banned states, 2 from southern states and 1 from the Midwest, one of whom had economic privilege, and 2 of whom had had support from families, friends, and abortion access funds to be able to travel. And that travel is not just about, it's the whole logistics and access to care. It's the bus or the plane ticket, it's the lift, it's the hotel room, it's the Airbnb, it's the food, and maybe it's also the child care, because we know that 2/3 of people who have abortion care are already parenting, many of them to young children. So that abortion access funds are really working to look at all of that to make care a reality. The other thing that somebody who finds themselves unexpectedly and unhappily pregnant in a banned state could do is they could self-manage their own medication abortion. And this is where life after Roe is very different from life before Roe. In the pre-Roe era, when abortion was criminalized, there were horrific ways that people could try and self-induce an abortion that were dangerous and often deadly. That is no longer the case. Medication abortion, which is a combination of mifepristone and misoprostol, two meds that go together, is highly safe. And we know from good scientific studies that people can understand the medications, understand how to use them safely, and have very safe outcomes. So that really in the post-Roe world, in the Dobbs era, self-managed abortion is very medically safe, but it does come with legal risk, because there are some states where self-induced abortion is on the books as a crime, or where other laws can be interpreted to prosecute people who self-manage their own abortions. Another option that people have, aside from travel and safely self-managing with medication abortion, is there are still dangerous alternatives. And some people might not have access to the information about how to access medication abortion medicines outside of healthcare. So that we can expect that some people will still resort to dangerous alternatives. And I also want to lift up this idea that people of privilege will be able to travel for abortion care, and so they're not really going to be affected by this. Well, that is largely true, because most people who need an abortion are able to have time to think about it and plan for it. I do want to lift up that for people with pregnancy complications, maybe somebody was happily pregnant and then something went really wrong medically in the pregnancy, that could be anyone, that is unpredictable, and the onset is often really rapid and does not allow for travel out of state. So that those are circumstances that you might have seen in the lay press about patients who are in a banned state and start having a second trimester miscarriage process, where the amniotic membrane around the pregnancy, or the bag of water in layperson's term, where that breaks early. And when it breaks early, the outcome for the pregnancy is fairly doomed. And the risk of continuing the pregnancy is that the pregnant person could experience infection and onset of sepsis. So that there are places in this country now where the standard of medical care that would keep patients safe is no longer allowed, and where doctors have to watch their patients get sick and get sick enough to be able to then have abortion care. So they need to spike a fever, they need to have a white count, they might need to be transferred to the ICU before the doctors are able to intervene in a way that their institution or they themselves feel minimizes their own legal exposure. And this is horrifying and egregious to me. Because when you think about exceptions to abortion bans, there's this idea of there's a health exception or there's a life exception. But in medicine, we don't separate those two. We don't let somebody get really, 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 really sick and then, oh, psych, we can save your life, maybe. We protect our patients' health from the get-go. So this is really creating dangerous situations for patients and moral anguish for their healthcare providers to have to watch somebody get sick when you could prevent it. So I do want to think about what is it like to be an OBGYN in the post-Dobbs era. And that it does come with this sense of uncertainty, fear, legal risk, and as I said before, a moral injury of knowing that something is wrong, but being unable to address it when you otherwise could. And that this is really an agonizing time for some of my colleagues around the country. We also need to think about what does it mean for the future of reproductive health care in this country. In medical education for OBGYNs, there's a requirement that all residency programs, the training programs after medical school, that all residency programs provide access to abortion care training. But now we have 19 states that have fully banned or severely restricted abortion care. And, you need to think about how are you going to make access to that training possible for people in a banned state. It's logistically impossible to say, let's take all the residents from the banned states and have them do away rotations in access maintaining states. That's just not feasible. So that there is a lot of creative thinking going on in medical education, but it is going to be imperfect at best, as far as ensuring that the next generation of OBGYNs have the skills required to provide safe, patient-centered abortion care. It also has implications for the workforce in OBGYN. Most OBGYN applicants are female and support abortion rights. So this coming March will be the first residency match since the Dobbs decision. And we'll see what happens. Did everybody want to go to an access maintaining state? Were those the highly competitive slots? Are residency programs in banned states going to go unmatched and not have enough residents to help run their hospitals? It's going to be a really interesting day in March when the match results come out. And I want to get back to that idea that the Dobbs decision is really going to widen the disparities that we see in sexual and reproductive health outcomes for people of color, particularly Black people, because we know that minoritized communities are hurt first and worst by the most restrictive health policies. And that in these states that have criminalized abortion care, we can expect pregnancy-related disparities to widen. If you take a Black woman who's 3 times more likely to die from pregnancy and tell her she has to stay pregnant, and you make it incredibly difficult for her to travel or access care, she's going to be more likely to die. The other piece that comes up is that we can expect communities of color, particularly Black people, to have a mistrust of the medical community in banned states if health institutions are seen as policing the bodies of Black people. And that this loss of trust, or this further erosion of trust, has significant implications for the health of these communities. I'd like to talk about 2 other topics. I realize I'm not looking at the chat, and I just want to make sure that I'm okay for time. Plenty of time. Thank you, Michelle, my real-time question answerer. I do want to lift up this idea of, first they came for abortion, next they came for contraception, that this is a very real concern. And you can see the FDA already trying to address some of that when they came out with a statement, I think about 6 weeks ago, about the mechanism of action of emergency contraception, that Plan B, or the morning after pill, is contraception. It is actually the same hormone that's in a lot of birth control methods. It's not at all related to the medicines that are used to produce a medication abortion. But those 2 things often get confused between Plan B and the abortion pill. They're totally separate. And the FDA came out and said what we've known, in the scientific and medical community for decades, that Plan B is not an abortion. If you are pregnant and you take it, it will not do anything to your pregnancy. It's actually related to a medicine that we give to help prevent miscarriage. So the FDA is trying to get ahead of the game and making the science clear about what emergency contraception is and is not. And I think the other area that I want to lift up here in Connecticut is thinking about what are the things that we at Planned Parenthood of Southern New England are doing when we look at issues of health equity, when we look at issues of access to timely abortion care. Some of you may have followed the Connecticut legislative process last year when Planned Parenthood of Southern New England, along with coalition partners and along with legislative champions, changed the Connecticut abortion law to remove the restriction that you have to be a physician in order to provide a first trimester aspirational procedure abortion. so that Connecticut now joins 14 other states to allow advanced practice clinicians who are midwives, advanced practice registered nurses, or physician's assistants to train in and to provide aspiration abortion procedures. So that with that, we at Planned Parenthood have trained some of our clinicians to provide the procedure, and they are a part of our pool of providers who patients see when they come for procedure abortions. In this coming legislative session, we're going to continue to expand on access to abortion for residents of Connecticut and for people who will travel here for care, including looking at access to medication abortion on college campuses, and also to work with legislative partners in looking at increased protections for healthcare providers who are providing legal care in Connecticut that might be banned in other states. We are also a proud member of the Husky for Immigrants campaign, because when we look at other barriers to care for people who are undocumented immigrants, when they don't have access to Husky, they don't have access to abortion care, which is covered under Husky. So that we're going to continue to be a part of that coalition and work to ensure that immigrants, regardless of immigration status, are able to enroll in Husky if they otherwise meet eligibility criteria. And that it's really a critical policy when it comes to health justice for those communities in Connecticut. So that we are going to be working on our top priorities with our legislative allies in the Reproductive Rights Caucus and the Coalition for Choice in this current legislative session in Connecticut. And I'd be happy to answer any questions about that in the discussion. Thank you for allowing me this chance to share some of my thoughts about what's coming next. I think now I turn the proverbial mic over to Ken.
I think I'm gonna grab it before Ken.
Oh, please grab it.
And thank you so much. I feel like it's so helpful to hear what's going on, the reality in terms of how it's actually affecting medical practice. And, and I think I'm not going to show the slides anymore, but, the prior slide really showed where states have made abortion illegal. And typically in those states, what they do is they make it illegal to provide healthcare, right? So it actually, usually the laws really target practitioners and doctors, and some of them even have lengthy criminal sentences, right? So just thinking about, doctors who have to make the decision about whether they're going to perform an abortion, and often, sometimes there's as Dr. Stanwood was saying, sometimes there's an exception saying you can provide an abortion if someone's life is at risk, right? And you have to make that decision on the spot, and then you're facing like 20, 25 years in prison, right? You're going to lose your license, right? So imagine that's a crazy way to ask. It's a crazy thing to ask of anyone, and it doesn't make sense as a way to practice medicine. But in addition to these laws that we looked at that actually ban abortion, there are other laws that states have passed trying to make it difficult for people to access abortion. So in addition to laws that make it illegal to have an abortion, states have tried to pass laws to prevent people from assisting other people from having abortions. They've passed, in addition to laws that make abortion illegal or criminalizing abortion, they've passed laws giving people the power to sue people who have performed illegal abortions. And we saw that, I guess, over a year or so ago in Texas SB 8 law. And that's that really sort of this novel idea that private actors can sue people who have an abortion. And there's an open question about whether those laws can also be used against people who help people seeking abortions go to a state where abortion is legal. I think that it's a stretch to make that argument, but I think we don't really know what's going on with, the courts have become increasingly conservative. And I think the other idea of a lot of these laws that are getting passed by anti-choice legislators is really to create that uncertainty, right? To create uncertainty, to sort of say, potentially you could lose your medical license, potentially you could get sued multiple times for providing abortions. And you don't, I mean, I think there's strong arguments that these laws are unconstitutional or improper, but we don't really know whether or not they're going to get enforced. And it's a lot of risk for people, for doctors to provide abortions under those circumstances, or for abortion funds to help people travel to other states. I think there's issues about whether abortion funds incur risk when they help people to travel to other states to have an abortion. But in addition to these, the negative things that we've seen getting passed by anti-choice states, we've also seen a lot of states take action to try to protect access to abortion. And this goes back to not just laws making it, creating a state constitutional right to abortion or protecting the right to abortion, but also laws that are, and policies that really target making abortion more accessible. And so Dr. Stanwood talked about that earlier in terms of several states passing laws deregulating who can provide abortions, right? So that we have more abortion providers. States passing laws or making funding available to actually create new abortion clinics or to train new providers, right? States passing laws making abortion coverage covered under Medicaid, states requiring that health insurance cover abortion services. Like these are, it's interesting in terms of, as we've sort of seen the threat on abortion and people rising up to defend abortion, I think there actually have been a lot of states actually passing laws that get to this access issue, which I think has been a good thing. And one thing I think I want to also hold up is a number of states have been passing laws trying to insulate providers from laws from other states. So for instance, if a doctor provides an abortion for someone who has come from a state where abortion is illegal, states have actually been trying to pass laws to shield the providers. And these include laws that protect providers from investigations or lawsuits or negative disciplinary action or malpractice for providing abortion or legal medical services in their state. And we've seen states like Connecticut, New York, Massachusetts, and New Jersey pass these laws. They've also passed laws creating a reverse cause of action, which includes the ability. So if you're a provider in New York who provides an abortion for someone from Texas and you get sued, you can actually sue the person who sued you. They've created a cause of action that says, I think it's like interference with protected rights. We've also seen cities like Austin, Atlanta, Tucson, cities in anti-abortion states saying that, you know, they're not going to allow city funds to be used to track abortions or to provide information about people who have abortions, that police should deprioritize arrests. So it's just interesting to think about how at the state level, we're seeing different levels of government trying to weigh in and trying to support or to repress access to abortion. Now I'll turn it to Ken.
Thank you. I'm going to talk about stare decisis, but before I do, I want to talk about touch on a couple things. The first is state constitutions. Litigants often, when thinking about litigating fundamental rights or constitutional rights, immediately go to the federal constitution, but the federal constitution provides a floor, and state constitutions often go beyond what the federal constitution provides in terms of protecting rights in various areas. That's why we have marriage equality in Connecticut and a number of other states, for example. So there have been a number of states, there are probably 10 or so, that the courts have recognized the right of privacy or a liberty interest or an equal protection claim that protects abortion rights. These include Kansas, which decided on sort of a liberty and autonomy basis. The right to privacy was the basis for decisions in Alaska, California, Massachusetts, Minnesota, Montana, New Jersey, and most recently South Carolina, just a week or so ago. And then equal protection was the basis again for Alaska, but also Arizona and New Mexico. and states have gone the other way. Idaho, on the same day that South Carolina said there is a right, said no, there isn't, and basically followed the same reasoning as Dobbs, that it's not deeply rooted in the state's tradition. The Iowa Supreme Court had held that there was a right to abortion, and then overruled this decision recently. So there are other states where there may be fertile ground, and certainly the states that already protect abortion access, it's that's superfluous at this point. But states where it's limited or banned may have that as a route. Now, there's also the matter of amending the Constitution or having propositions in order to protect abortion rights. And that's the last 2022 was very interesting in that regard, because in the November election, California, Michigan, and Vermont added protections for abortion rights to their state constitutions. Connecticut, or not Connecticut, Kentucky rejected an amendment that would have prohibited an abortion. And then earlier in the year, Kansas had rejected an amendment that would have overruled the favorable decision by the state Supreme Court. So, if you're a litigator and you're in a state where abortion rights are at risk, look to your state constitution. There may be something you can do there. A legislative response by Congress to the Dobbs decision that doesn't address abortion is the Respect for Marriage Act, and this responds to Justice Thomas's concurrence, in which he basically suggests that Griswold, Lawrence, and Obergefell should be overruled. Obergefell, of course, is the marriage equality decision at the federal level. So a little bit of background there. In 1996, Congress passed the so-called Defense of Marriage Act, or DOMA, and it was in response to the possibility that some states would start recognizing marriages between same-sex couples. And it defined marriage for federal law purposes as the union of one man and one woman, and also told states that they can ignore marriages between same-sex couples that were legally performed in other jurisdictions. The United States Supreme Court struck down the DOMA in United States versus Windsor in 2013, so it's an unconstitutional statute. But what the Respect of Marriage Act does, one of the things it does is repeal DOMA. So if for some reason Windsor would be overruled, DOMA can't rise out of the ground like some legislative zombie that they've cut the head off of it, at least, unless Congress changes that law. And it recognizes that marriage as valid as between two people. It's valid in the state in which it's entered into, or jurisdiction. And it requires states to give full faith and credit to marriages that are validly performed in other jurisdictions. So if Obergefell goes away, there are still at least 17, maybe 20, 21 states where marriage between same-sex couples will remain legal. You can go to one of those states, get married, and go home to your state and have the state recognize it according to federal law. It also provides some protections for religious institutions. Churches, nonprofit religious institutions are not going to have to perform marriage rites that are inconsistent with their theology. But it doesn't go so far as to protect the florists and the photographers and the website, the cake bakers and all of that. What the Respect for Marriage Act does not do, it does not require states to license same-sex couples' marriage. And it doesn't, importantly, protect other privacy or liberty interests. And it also, it affects not only same-sex couples, but also interracial couples. Whether Loving versus Virginia would ever be overruled or not is not clear to me, but for purposes of completeness, the act includes it. So with that, I want to turn to stare decisis. Now, it's for the non-lawyers in the audience, stare decisis simply is the principle that you should follow precedent or follow a case, even if you think it's wrong, unless there's a very good reason not to. And the Casey decision talks a lot about stare decisis, because in Casey, the court was asked to overrule Roe versus Wade, and the majority said, no, we're not going to do that. And it set out the reasons why, or the reasons the court shouldn't overrule it, and the things that the court should consider. For example, is the decision unworkable? And Roe was not, according to the Casey. Is there reliance on the decision? And the answer is yes, both in terms of how the law has developed, think of Lawrence, for example, or in other cases, but also, people organize their lives on the notion that, if birth control fails, they have a backup plan. And maybe they decide where they're going to live based on being able to have access to abortion. Another factor that the Casey court considered was the legal developments, under that decision, but what followed from Roe. Well, Roe was part of a chain of cases that talked about liberty and autonomy. And so it's part of that fabric. And then finally, are there any factual developments that rob the old rule of significance? And Casey said, no, yes, it's still controversial. It's always going to be controversial, but we don't know that, and that's not a change in the facts on the ground. The majority in Dobbs took an entirely different, largely different approach. Their first criteria was whether the error was, quote, egregiously wrong. It's not clear to me what that means, other than they really, really hate the decision. They give an example of Plessy versus Ferguson was egregiously wrong. Well, yes, it was. And then, whether it's deeply damaging, which the court said Roe was deeply damaging because it usurped the democratic process. Anytime the court strikes down a statute for being unconstitutional, it's usurped the democratic process. So I'm not sure that really sets that apart from any decision that the panel thinks is wrong. The next is the quality of the decision, quality of the reasoning. And this was basically after having shredded Roe and Casey, went back and shredded it again. And so, as far as the reasoning goes. The next is the workability test, which was also a factor under Casey, but they said, well, there's this undue burden test, and there's all this litigation because we don't know where the line is, and it's just unworkable. Well, but anytime there's a general rule that's going to be applied on a case-by-case basis, you're going to have litigation testing the limits. Another factor the Dobbs court considered was the effect on other areas of the law. And they said that, Roe versus Casey, it dilutes the law on standing because abortion is a short term. They usually have providers, or somebody else has to have standing, and distorts other areas of the law as well. And then here's the one that really irritated the dissent. The court said, well, reliance really isn't a thing because, reliance is most important when you're planning. You don't plan to have an unplanned pregnancy. So therefore, how can reliance be a thing? So they're really looking for sort of the concrete reliance that, you signed a contract or made, business arrangement, or they're thinking more in commercial terms as opposed to actually human terms. And then one of the things that Casey had said is that, look, we have to be, when you're talking about important precedent, you have to consider the court's reputation. And if it just pull the rug out, it's going to undermine the public's view of the court. And the majority said, well, we don't really know how Dobbs is going to be received, which is clearly not true because it was leaked and was not received well in the leak. But setting that aside, they said, well, we can't let that influence our decision. Oh boy. Now, Justice Kavanaugh had concurred, and he was focused mostly on the so-called egregiousness of the error, the negative real world or jurisprudential consequences, and then reliance factors. So what does this mean? I mean, we know what it means, or we're learning what it means in terms of abortion rights, but what about other fundamental rights, other rights pertaining to liberty and to autonomy? Now, there's this lovely line of the majority that says, quote, nothing in this opinion should be understood to cast doubt on precedents that did not concern abortion. And this is because contraceptive and same-sex relationships do not involve potential life, and each has its own stare decisis analysis, all of which is true, but I'm an appellate lawyer, when I'm litigating a case, I have to figure out how am I going to get, 2 out of 3, 4 out of 7, or 5 out of 9 votes. And it's clear to me that the only reason that sentence is in there was to get a 5th vote, probably Justice Kavanaugh's, because he concurred separately to emphasize the point about this doesn't affect other rights. So, okay, well, let's take them. But then, as the dissent points out, Justice Thomas was not with the program because he said the quiet part out loud that we should look at all of the substantive due process cases. And he specifically mentions Griswold and Lawrence and Obergefell, although I don't know why he doesn't mention the earlier cases, like the fundamental right to marry or the right to send your kids to private school or any of those cases, but he doesn't. Now, Justice Thomas is, a so-called originalist and textualist, and his view of the 14th Amendment of the Due Process Clause is that liberty means freedom from physical restraint, and that what the Due Process Clause means is that you can't be physically restrained by the state without due process. That's all it means to him. So there are no fundamental rights as far as he's concerned. I don't know that he has anyone else on the court that would go quite that far. I think that Justice Alito would happily go along with overruling Griswold, Lawrence, and Obergefell. The others, it's not as clear to me. But let's take them at their word in terms of their stare decisis analysis and run through the cases. I'm going to start with Obergefell because I think that's the one that probably survives best. Now, presumably, the majority thinks that Obergefell, Lawrence, and Griswold are egregiously wrong. I'm just going to assume that because why wouldn't they? It's based on these liberty interests that are not expressly spelled out in the Constitution and didn't exist from the Garden of Eden. So, in terms of workability, Obergefell is simple. You get a marriage license as long as you meet whatever other standards are required. But there's all this litigation now about, well, what about the baker who doesn't want to make a cake and the website designer who does, and it's going to be all this, so it's just not workable. I mean, the problem with that analysis is that of the 17 or 20 states that would still have marriage equality after Obergefell, most of those, if not all of them, have some sort of gay rights law or protect on the basis on the sexual orientation. So you're still going to have these cases. So that's not going to go away, but I'm sure that's what they would say. The effect on other areas of the law, I mean, I guess religious freedom, but my guess is that they're just going to chip away at, that the religious freedom is always going to win. But the area that I think that certainly I would hope that Justice Kavanaugh, and by the way, I don't think the Chief Justice is going to go along with overruling any of these cases because he saw the blowback, shall we say, is the G-rated term from what happened with Dobbs. I don't think he wants to go through that again with Obergefell. I think that Justice Kavanaugh probably is sensitive somewhat to that. But in terms of reliance, a quick Google search, I found in 2019, there were at least 500,000 same-sex married couples in the country. Now, a lot of those are in states where it would remain legal, but what about the hundreds of thousands that got married in reliance on Obergefell? What happens to them? Are they still married? Are they not married? They have kids. What happens to their relationships kid? What happens to their estate planning? What happens to their insurance coverage? There is concrete reliance that I would think that even some of the more hard-nosed judges and the minority or the majority of Dobbs would have to recognize. So I think that without a change in the composition of the court, probably Obergefell is going to be okay. It'll get chipped away at in terms of religious liberty exceptions, but the core right will probably survive. Lawrence, I think Lawrence rises or falls with Obergefell because if you get married, you expect to be able to engage in intimate behavior, and that's going to, so people are going to be relying on that. The case that maybe is a little bit on the ropes is Griswold, because the reasoning, as I mentioned, the penumbra, this notion of penumbras protecting rights has been attacked. And even though it's now thought of as, the right of privacy is a 14th Amendment right, if you have justices who don't believe in fundamental rights through the 14th Amendment, that's going to be a problem. It's not unworkable in the sense that there's been a sprawl of litigation and debates, but there are states that are considering going after some forms of birth control that are viewed as not necessarily contraceptive. Whether that's medically or scientifically accurate, I'm not the one to answer that question, but that doesn't prevent legislators from acting on their own beliefs about that. In terms of reliance, I mean, at least it's called family planning, so you're planning. So maybe there's more reliance on Griswold than Roe or Casey, but that might be the way they start chipping away at some of the fundamental rights. And I will stop talking now and let someone else talk or ask questions. I guess we're questions and answers now.
Dr. Stanwood had asked to be able to put a couple of links out to everybody. And so Dr. Stanwood, I'd just like to invite you to put those links in and just describe briefly what the links are for, please.
Yeah, thank you. I hope the links are working. Some of them don't look linky. The first is a really excellent article, and don't be intimidated if you're not in the medical field. It's actually very concise and readable for a non-medical person. It's called Black Lives Matter, Claiming a Space for Evidence-Based Outrage in Obstetrics and Gynecology. And it goes through those health disparities that we see between Black and white people in the United States. The second link that does look like it's a link is to information about the turnaway study that I talked about, people who are turned away from having an abortion. Abortionfinder.org is an incredibly important website for people who need to find an abortion. It accurately and up to date will map where people can go based on their age and their last menstrual period or their best guess about their dating of their pregnancy. I Need an A is one of many online websites. This one is very trustworthy, that can provide people with medication abortion and do that remotely, so outside of the healthcare system. The Reach Fund of Connecticut is Connecticut's abortion access fund, and full disclosure, I'm a founding board member of the Reach Fund, which some of us started working on about 2 years ago, and we launched our fundraising in mid-June. And I'm pleased to say that by the end of last calendar year, we had raised $100,000. And we this fall started funding abortions for people in Connecticut and those traveling to Connecticut. Then I also put a link in for Planned Parenthood Southern New England for our advocacy and policy information, and also a link there to Husky for Immigrants, which is the website for the coalition working to allow immigrants of any status to have access to Husky.
Thank you, Dr. Stanwood. That's very helpful. We have our first question, and this one is directed to Attorney Varsity. Ken, could you just tell us, is this the first time that the Supreme Court has taken away a recognized right?
Well, certainly it's the first time in a very long time. I suppose technically when the court overruled the Lochner era cases, it was taking away the right to contract such that you could have awful working conditions, but I'm not really sure that that's a right we want to hold up. But in terms of modern history, yes, it is. There's a the majority has has at some point talks about all the cases that have overruled prior cases, and nobody loses a gasket over that. Like Brown versus Board overruled Plessy, Lawrence overruled Bowers. But those are all of those cases advanced or broadened fundamental rights or equal protection. This is the first time really that the court has restricted or eliminated what has been viewed as a fundamental right.
Thanks, Ken. We have another question. Let me just read it out to everyone. And I think I'd like to kick it first over to Professor Suhu, maybe. This one says, Roe was both a fundamental rights / liberty decision, but also a medical decision. To what extent do you think that this implicates decisions like Cruzen and the underlying concept that liberty includes the right to be free from unwanted medical intervention, even those necessary to save a life? The corollary, of course, is to what extent it interferes with the ability to request necessary medical care. Professor Suhu, if you wouldn't mind jumping in on that one, and then anybody else who would like to, please do.
Yeah, I mean, I think first of all, just thinking, right, that the Justice Thomas doesn't even like substantive due process, right? And so, so I feel like that's going to be a challenge. I think also this sort of historic look at, you know, what the law has been over time and sort of what historic attitudes. I think that's going to be, that's going to have a negative implication. Yeah, I mean, I feel like the court really doesn't grapple with the fact that that Dobbs is really taking away people's ability to make medical decisions and sort of have autonomy over their own body and their own medical decisions. And sort of, it just ignores, I mean, that's, I think, one of the things that I find most frustrating, right? That just by saying that there was sort of historically abortion was illegal, therefore we're not even going to deal with these broader questions about taking away people's ability to control their bodies, I feel like it's problematic.
So, yeah, I mean, I think the dissent in Dobbs was, I mean, they didn't talk so much about Cruzen, but they talked about some of the other cases we've talked about. But, you know, this dissent says, does the majority believe its own reasoning? And if it does, then I think it does call into question these other cases. If the case, you know, if the rationales that the state has an interest in preserving life, well, how does that affect a decision, you know, by someone to withhold medical care because they are dying and they don't want to be have the process prolonged? That's, I think, something people are going to need to worry about, and get your living will if you don't have one, you know.
Dr. Stanwood, I think that the corollary is more addressed to you. So to what extent do you think that this decision actually interferes with the ability to request necessary medical care? I mean, for example, we have seen all of those reports about women in emergency circumstances whose care is being delayed, sometimes denied, with you know, obvious negative effects. You know, what are your thoughts about that?
I think it makes for terrible medicine. I think we have excellent public health and scientific evidence to say that timely access to safe abortion care is critical for the health and well-being of people who can get pregnant. And that whenever we see legislation interfere with medical practice, interfere with scientifically accurate and evidence-based medical practice, that patients get harmed. And I like to tell legislators and justices, some of them, that they should just stay out of my exam room. That, you know, myself and my colleagues are expertly trained, and we have our patients' interest first and foremost in our minds when we are counseling our patients and providing medical care.
Thank you. There are actually two questions that are almost the same question. So let me read the one out from the Q&A section. What are the panel's thoughts on certain Jewish groups pushing back on the court's deference to religious liberty by pursuing litigation to protect abortion rights? It appears that the court's idea of religious liberty may be a Christian one. Is this a winning strategy?
Well, I feel like it's an exciting strategy. I feel like it's a good public messaging strategy, you know, and I think that the commenter is right that, the court talks about protecting religious liberties, but it really is talking about protecting the religious liberties of conservative Christians. I think that I haven't looked, I know that there was a case that was filed in Florida. I don't know, Ken, if you've looked at that case. I'm trying to remember. I feel like there's a technical problem in terms of people arguing that their religion requires them to have an abortion, and whether that's a distinction. But I think that there was an argument in the Florida case that it was about the establishment of religion, and that there were various fundamentalist groups who were involved in. I'm not an expert on the First Amendment. But I seem to recall in the Florida case, there was an issue about fundamentalist groups being involved in the drafting of the legislation banning abortion at 15 weeks. And then it was also about establishment of religion.
Well, and if I can give another angle on that, I'm a Unitarian Universalist, and I bring my faith and my religious values to my work as an abortion provider. So what does that mean when I'm told that I can't provide medically safe and sound care? What does that mean for my living out my values through my work?
Yeah, I think that's an excellent point. I feel like, another issue that we've been looking at in our clinic is religious refusals to provide abortions, right? And, I think that the law in the United States allowing providers to refuse to provide abortions, and even allowing institutions and insurance, companies that don't want to provide insurance, really goes way too far. And if you look at international human rights standards, there's sort of this idea that the right to refuse, religious refusal in the context of abortion, really should be limited to the provider themselves, and not to institutions, and certainly not to companies who don't want to provide insurance to people who may or may not have abortions, right? And just this idea that that's too attenuated, and that's really about the company trying to control someone else, right? And we need to think about what's the proper limits of claims of religious refusal.
Right. And you're getting to the idea of protections of conscience, and that there are strong protections for negative conscience. I don't want to do that because it violates my beliefs, but there are not equal protections of positive conscience. I feel compelled to provide this care because of my conscience.
Right.
So there's this, there was in 1990, it was Employment Division versus Smith, which was a case that dealt with religious freedom. Specifically the people who had been fired and weren't able to get unemployment because they had used a controlled substance for religious purposes. And what the Supreme Court said is that a law that is facially neutral and does not violate religious freedom is, even if it has some incidental effect on it. Now, the religious right hates the Smith decision, tried to get it overruled recently, and it didn't. Now, so the notion of members of the Jewish faith saying that the abortion right, or the abortion ban affects their religion, it seems like the answer would be under Smith is that that's an incidental, it's a neutral law that's not directed at anybody's religion, so it should withstand that challenge. But that's going to, I think, put the conservatives between a rock and a hard place if they, if they want to get rid of Smith, but then they're going to have to rely on it to make this other case go away. So I think it's sort of an interesting. It's going to force an issue one way or another.
Right. And I do feel like it's really important in the public debate and dialogue to just have this discussion about, people of different faiths have different views, and why should we be, a country that increasingly, in many states, have laws related to abortion that reflect the religious views of just one group, right? So I think it'll be interesting to see what happens in the courts, but I think it's a really important dialogue for us to be having.
We have another question that's somewhat related. We spoke in our prep session about the question of birth control And we also spoke again about it tonight. And in our prep session, we discussed, the issue of birth control. What's actually very important is how is it defined? Is it defined as a contraceptive or, and I apologize for my pronunciation, an abortifacient? And who gets to decide? And I think that some of these questions go to that exactly. I know Dr. Stanwood was excited to talk about this question. So let me just kick it off to you first, Dr. Stanwood, if you wouldn't mind.
Yeah, thank you. The medical definition of pregnancy is you have a positive pregnancy test. That means that either in your blood or your urine, we know you're pregnant. So that just because egg has met sperm doesn't mean that somebody's pregnant. I like to think of the thought experiment of somebody who is getting pregnant by IVF and the egg and the sperm are over in the refrigerator. Are they pregnant? No. So the definition of being pregnant is you have a positive pregnancy test. So that contraception, by definition, prevents pregnancy. And things like Plan B, emergency contraception, prevents ovulation and prevents the meeting of egg and sperm. It prevents conception. When we talk about what is something that causes an abortion, that would be a pregnancy that was established, meaning the egg and the sperm met, traveled into the uterus, implanted in the endometrial lining and the lining of the uterus, and set up the biochemical process to make a pregnancy test turn positive, and then it turned positive. So that abortion is anything that disrupts an established pregnancy, such as a procedure or taking medication that can make the uterus cramp and push a pregnancy out, which is what medication abortion is, that second scenario. So they're distinctly very different, and it all revolves around what is the definition of pregnancy. So that first and foremost is a scientific medical definition. I hope that answered the question. Happy to take follow-up questions.
I mean, I feel like it's so important for us to talk about that, and to also talk about that, we should be looking to the medical definition, and I think one problem in the law is that we've sort of seen the expansion of religious liberties, like in the Hobby Lobby case, right, where certain people saying in their view, in their religious views, right, certain types of contraception are abortifacients, and therefore they shouldn't have to provide insurance coverage for those types of procedures, right? So then it sort of becomes this question of who gets to define, and I think it should be science. But at least in the context of religious refusals, the Supreme Court has said we're gonna just defer to people's, I think, honestly held beliefs, right? Which I feel like is just asking for trouble. But I think there we are.
Well, and I like to think back to, I'm going to forget the year because of the pandemic, A Whole Woman's Health, early 2020.
2016 is Whole Woman's Health.
Was it 16 or 20? I feel like it was
16.
20.
June Medical was 2020.
Thank you. Then it's June Medical I'm probably thinking of. Where the court at the time said, oh, we should not just take a state legislature's say for it that this is factual, that we need to examine the medical and scientific facts. And in my mind, I have this little thought experiment, a state legislature could say that the moon is made of blue cheese. They could, but that doesn't mean that it's made of blue cheese and that you can check that factually.
Yeah.
So I appreciate you lifting up the idea that we have science and medical evidence that can be looked to gauge the accuracy of claims.
I think a lot of times, like when you look at the legislative history of some of these anti-abortion laws, there might be like one random, really questionable study, right? Like in terms of like fetal pain and other things, right?
Mm-hmm.
And I think that what happens is you have these studies, which I think often really have been discredited, or most doctors would not rely on it, but then they get thrown in, and then the legislature says, there's a disagreement. And in the face of this disagreement, we're going to defer to the legislature. And so I feel like we're also stuck in this world of alternative facts and sort of manufactured facts. I think that sort of adds to the problem.
You're right. It definitely does.
You know, a thought that I had as I was listening to the both of you is that, you know, when we talk about religious freedoms at the individual level, I mean, I think that is one thing, but it has the feel at this point, although they were very careful not to cite religious preference, that we're actually starting to get into the realm of policymaking. And when it comes to policymaking, if that has the feel to me of an establishment clause issue, and I just wonder if somebody might want to comment about that.
Yeah, I feel like I'm not like an establishment clause person. I don't know if you are either. So.
Well, as you guys are duking that out, I will just say that, because I'm not an establishment clause person, definitely. I will say I just dropped something in the chat that is a seminal report by the National Academy of Medicine that looked at the past 30 years of scientific evidence around safety and quality of abortion care in the United States, and looked at whether or not the science was adequately performed. So it assessed, were these quality reports, are they worth making policy decisions on, et cetera, et cetera. And I've just put a link to that report. It's like a 500-page report. Do not read all of it. They have an executive summary.
So on the establishment clause issue, I think, you know, unless it's facially supporting a particular religious view, I think it's probably the fact that there may be, you know, language in a debate that is of a religious origin, I don't think is going to influence a court's decision. The court, you know, is generally going to presume that the legislature is acting rationally and properly, and the fact that, you know, some people may say things that they're not going to necessarily impute that as a motive unless it's inescapable or really egregious. And I think that the legislatures usually are smart enough to avoid, you know, going too far over the line to create. So even though we all know what's actually going on, they will have covered their tracks sufficiently or given enough fig leaf so that the court will not impute some sort of religious motivation to any particular piece of legislation. And the fact is, and you know, to the extent that there are other religious groups or views that support abortion rights, you know, they have a right to say, you know, to advocate as well. So, you know, I don't know that that's gonna be a winning strategy.
All right, we have another question in the Q&A, and this one I think is very interesting. The question reads, may I ask what the role of fathers or pregnancy contributors is in the post-Dobbs world, especially if they're in support of their partner's abortion? Do they have a legal interest at this point?
You know, interesting, because I feel like the question usually is asked in terms of partners who disagree with the abortion decision. So this question is really about sort of the fathers or the male gamete providers who don't want to become parents. Is that?
Yes, that's how it reads.
Yeah, I mean, it's interesting in terms of, like, I looked at some IVF cases also about, you know, about frozen pre-embryos, you know, in terms of disputes about, you know, whether or not they were going to be given to one parent or another, right? And where one wants to, I guess usually the mother or the potential mother wants to become inseminated. And I feel like those cases say, you know, the father has a right, or the prospective father has a right, constitutional right not to become a parent. And so there is a question in my mind whether that's still good law, right? This idea of the right to choose or not to choose to procreate, whether that disappears with Dobbs.
I guess if the logic of Dobbs is that, I guess, is because abortion involves potential life, then the state can legislate in favor of potential life by banning abortion. I suppose, could the state provide some sort of protection for the contributors of the gametes to have a say in the, in other words, does this undo, the notification, or the ban on notifications and that sort of thing?
It's only because I feel like Dobbs really doesn't turn on the state's interest, because it's really saying that there's no historic right to abortion. There's no historic right to have an abortion. So there's no constitutional protection. And so there's no historic right. I mean, obviously we didn't have IVF, right? So there was no historic right to not have your eggs implanted. But I mean, I do think because the decision really focused on sort of the lack of historic recognition of the abortion right, that, there's an argument that there is no right not to procreate. And even thinking about Skinner, yeah, it's scary.
Well, let's kind of wind it back a little bit. I mean, we have some questions about, for example, the personhood statutes and the tension that you might have when you think about if there is no right to an abortion. If you flip that, is there then some kind of potential criminal activity or other test before a pregnant person could undergo certain medical treatment that might harm the fetus? Is that where we're going with this? Is that what could be down the road for this?
Well, and I'll just say that's certainly how early on Dobbs is playing out for some specialties. I was on a panel discussion a couple months ago with the Yale Cancer Center talking about pregnant people who need to have treatment for cancer. And what does it mean if they're going to take a chemotherapeutic agent that might cause harm to the fetus? What does it mean for the doctors who want to prescribe that? So I'll say that this isn't theoretical. It's actually playing out in banned states now. And if I may, well, I have the mic. I feel that I would be remiss if I didn't lift up an important concept for the group that is not legal, but is, well, somewhat legal, based in human rights, is the idea of reproductive justice. Reproductive justice is a woman of color created, led, organized movement that I've just dropped a link in the chat to a great definition by a group called Sister Song. They define reproductive justice as the human right to maintain personal bodily autonomy, to have children, to not have children, and to parent children we have in safe and sustainable communities. And that this is an organizing principle for the person of color led movement around reproductive autonomy. So I just want to circle back to our overarching theme of racial disparities in the law. And for those of you who might not know about the principles of reproductive justice or know the amazing organization Sister Song or other affiliated reproductive justice organizations, I just want to make sure that this audience hears about that and has a chance to explore that link. So thank you for letting me jump in there. Back to the law, up to you.
Wait, Michelle, can you re-tee up the question?
Yeah, sorry. So the question had to do with the tension between the rights of the fetus versus the rights of the pregnant person to actually undergo medical treatment that may adversely impact that fetus. Are we looking at a problem? And I gather from Dr. Stanwood that we actually are. This is being discussed for real. And what are the legal implications of that tension?
Yeah, I mean, I think there's two pieces, right? I think there's the piece of not having Roe anymore, but also whether or not, or the extent to which the state recognizes the fetus, or even I think embryo or zygote as a separate person or a separate patient, right? And I think it doesn't necessarily follow that just because Roe versus Wade has been overturned, that we're automatically recognizing that fetuses are persons or independent patients. I know it's more complicated in the medical field, but you know, that said, I do think, Michelle, that there are states where they have said that the fetus is a child, so therefore it's protected by child endangerment laws, right? There are statutes that say if a third party harms a pregnant person and it results in the death of a fetus, that's an independent homicide. Most of those states, though, have exceptions for actions by the pregnant person. So there's sort of a recognition that those laws are really about harm or violence to a pregnant person that causes loss of pregnancy. But some of them sort of suggest that this idea of fetal personhood, which I think is a very dangerous idea. And I think that while there are laws that sort of have been passed that create certain protections for prenatal life, I don't think they should be interpreted as going so far as recognizing the fetus as a person. And increasingly, like, there was actually a cert petition to the Supreme Court after Dobbs asking that the Supreme Court recognize fetuses as people protected by the Constitution. The court rejected that. And again, and it goes back to the court rejected that in Roe versus Wade, but I think we're increasingly going to see these types of claims from the right, because I think the prenatal personhood people have become emboldened.
I think from a historic standpoint, they would have a hard time claiming that a fetus is a person or was considered a person in 1868. So maybe this is one instance where historical perspective is actually protective in terms, at least in terms of a constitutional right, but that doesn't necessarily mean that the states can't pass statutes or not. And so then the question becomes, how does, I guess if there's no right to abortion, what is there to balance? You know, so I'm not sure what the theory would be to attack.
Right. I mean, I feel like there could still be limiting principles in terms of if you're trying to regulate a pregnant person, you know, do they have independent rights to make medical decisions on their own? You know, because I think this also goes to like issues, and Dr. Sandwood, maybe you've seen this as well, like for C-sections, or right when the government intervenes to make healthcare decisions that a pregnant person wouldn't make to protect the fetus.
Yeah, that's a very thorny topic, but I will just say that anytime a medical team feels like they need to call a court, I think maybe they need to consider how they're centering and talking to the patient.
Agreed.
It looks like we are just about out of time, and I believe that is unfortunately going to be the last question that we're going to be able to discuss. I'd like to turn this over to Jenna Cutler to close out the rest of the panel. But before I do that, I would really just like to say thank you to our panelists for doing such a wonderful job at presenting on this very, very important topic and so thoroughly covering so many of the issues. Jenna?
Thank you, Michelle. And to echo what Michelle said, I think we all want to thank the three panelists today for joining us for this session of The World According to Dobbs. We also want to thank all of you for joining us, and really thank you, our speakers, for sharing their knowledge and expertise. If we could also thank the Connecticut Bar Association, the Connecticut Bar Foundation for holding the Constance Baker Motley series and for having us here today. Currently, the next session of the Constance Baker Motley series is tentatively scheduled for March 15th. I have been told it will be discussing racial trauma and the impact of over-policing and its involvement in the criminal justice system. If everyone would follow the CBA and the Connecticut Bar Foundation communications for more information about the upcoming series speaker events, and please make sure you check the chat before you leave for information from this session and for all the verification codes and survey links. Thank you, everyone, for being with us tonight. Have a great rest of your night.